Hello, my name is Billie Tarascio. I'm an Arizona family law attorney. I own Modern Law, and we're a family law firm here in Arizona. We represent people throughout the state, but Modern Law has a long, long history of supporting access to justice and putting out lots and lots of information and resources for the public who are representing themselves. We know that many, many people are representing themselves in family court and should have information that they need in order to represent themselves well. I have been a lawyer in family law for the last 20 years and am excited to do a crash course today in everything that you need to know, not really, but a lot of what you need to know for Arizona family law. Fantastic. Here's what you can expect today. We're going to go over a high-level guide to Arizona divorce. Divorce is a emotional transaction, and then it's also a very complicated practical transaction. So that's what can make it so complicated and take so long and maybe be more complex than it needs to be. So this session is designed to give you the tools to represent yourself effectively, and it is focused on Arizona law and procedure. So while this information is for you, it probably won't cover everything that you possibly need to know, and it of course is not the substitute for having an actual lawyer or legal advice. All right, so if you've got questions, let me know, jump in. But essentially, the fact that divorce is two things: the emotional breakup that you are going through, like processing the end of your relationship, and then kind of separately or at the same time, you have to do all of these practical things to dissolve the business of your marriage. And the business of your marriage couldn't be more personal because you've got kids, you've got money, you've got housing, you've got stability. It's what makes this so hard. So today, this is for anybody who doesn't have a lawyer and is representing themselves, anybody who maybe is thinking about a divorce, but you haven't filed for divorce and you're just gathering information, or if you just really want to understand divorce law better. Maybe you are a brand new attorney and you're thinking about getting into family law, or you're a law student and you're thinking about family law. This should be useful to you. So the steps to getting divorced, and this is definitely the procedural side, are these. Somebody files a petition, the other party is served, a response is filed. You might get or need a temporary order in place to determine temporary support, temporary custody, who's going to pay the bills on a temporary basis until you get divorced. Then you've got disclosure and discovery, where you pass information, you gather information, you figure out who are going to be your witnesses, what is going to be the evidence that you need to present in order to dissolve your marriage. And then, are you settling your case? Do you go to trial? How do you get a final decree? Okay, so now some of these steps are optional, and we will talk about that because this is what happens most of the time, but there are other ways that you can bypass some of these steps. But normally in a normal divorce, these are the steps. So there are two main sources of rules and information that you need to know if you are getting a divorce. And that's the Arizona Rules of Family Law Procedure, which governs the rules of how things must be done, like how service is made, how many days you have to respond, how to get a temporary order, what you can ask for in your temporary order. That is covered largely in the rules of procedure. And then you've got the statutes, which is Title 25 in Arizona, and that covers the law, what the legislature made to say, here's what the best interest of the child, here are the factors, here's how you get spousal maintenance. But there are different types of divorce. So this is what I was talking about a minute ago, where you've got all those processes that we just went through, except you don't always have to go through all of those processes. You can get an uncontested divorce through a summary consent decree or through a more traditional sense. So a summary consent decree is for those of you who are uncontested from the beginning. You agree on everything. You've already figured out what you want to have happen to divide your property, for parenting time and legal decision-making, you know what your parenting plan looks like, you have figured out spousal maintenance, you've figured out child support, you can do everything before you file anything. And that is the summary consent decree. And that will save you some filing fees. And it's like a fast pass to getting a divorce. If you can do it, I highly recommend you do it. Now, you can also do an uncontested divorce without doing a summary consent decree. And then what you would do, I'm just going to jump back here. Somebody would file a petition, and then you would either file a consent decree that the two of you agreed on without even filing a response, or you would file a response, and at a different point in time throughout these steps, at any point in time, if you agree on everything or if you settle all the issues, you can file a consent decree and fast pass and fast track your divorce. There is a 60-day waiting period though. So even if you file this summary consent decree process, you have to wait, or the judge has to wait 60 days between the time you file that petition for divorce until the time that the judge can sign off. And then there's a default. Okay, a contested divorce is where y'all don't agree. Somebody wants a divorce, somebody else doesn't. Usually this is because the emotional side, the breakup side, one person wants out and the other person doesn't necessarily want out. Or both people want out, but somebody doesn't want to file, either for religious reasons or moral reasons or personal reasons, they don't want to file. And you don't agree on things like custody, decision-making, parenting time. And then a default divorce is when someone files a petition and there is no response. So you have to file a response within 20 days if you're properly served here within the state, or 30 days if somebody lives out of state. And then if no response is filed, you can file for default. Now the 60-day waiting period is still in effect. So 60 days after that petition, no response, you can ask for a default hearing and the judge can give you everything that you wanted. The thing with the default is you need to make sure that your petition is specific enough for the court to give you what you want. Because the rule with defaults is you have to have given the other parent or the other party notice of everything that you're asking for. So if you file a vague petition, let's say it just says equitable distribution of property or reasonable parenting time, you probably don't have enough information in that petition to allow the judge to give you a default divorce. So that is something to think about. Not all divorces involve fighting. Many, many times, divorces can be settled between the parties. And sometimes people just need help getting this process taken care of for them. Here are the legal requirements to file for divorce. You need to have lived in Arizona for a minimum of 90 days. You should also know that we are a no-fault divorce state. That means it doesn't really matter if somebody cheated or if somebody was a bad spouse or all of the terrible things that they did during the marriage or all the ways they treated you poorly. It doesn't matter. The family court's business is simply to divide the community property and figure out a parenting plan, legal decision-making, and spousal maintenance. It's just the business of the transaction. And spousal maintenance is unaffected by fault. So it's unaffected by people being mean or even abusive. This unaffected, child support is unaffected by people being mean or terrible parents or abusive. It's simply the numbers that go in the calculator that determine what child support will be. The exception is if you have a covenant marriage. Now, if you have a covenant marriage, you are not allowed to file for divorce unless you meet specific grounds. Most people do not have a covenant marriage. In order to have a covenant marriage, you have to have gotten a special certificate, gone to special counseling. You needed to opt into this covenant marriage. And the only thing it does is it makes it harder to get divorced. It doesn't change the rules regarding that no-fault piece that I was talking about. It doesn't change the rules for spousal maintenance or child support or any of the specific issues within your divorce. But it can take longer to get divorced, and you have to live separately for a year, or you have to prove that somebody cheated. And now we do have to prove whether or not somebody cheated, but it won't make a difference again in the outcome for your property division, your spousal maintenance, or your child support. Here are the issues that you should think about before you go to get a divorce. What are the major issues, the major legal issues that have to be addressed during my divorce? There's property, which is property and debt, and figuring out which of your property is community property and what is separate property. Anything that you've acquired during your marriage, both debt or physical property by either of you, is generally speaking community property, subject to an equitable division, which usually means everybody gets half. It doesn't always mean everybody gets half, but it usually means everybody gets half. Half the debt, half the value of the property. You can't actually divide a house in two, but you can divide the value in two. And that is what happens usually in a divorce. Now, separate property is anything you owned before your marriage, anything that was gifted to you during your marriage, or any inheritance. That is separate property. It does not belong to the community. It is not subject to division. This gets a little tricky when somebody owns a house before they get married, and then the community pays down the mortgage for the separate property's spouse. And then what happens is you have what's called a community lien, where the community is entitled to some reimbursement for the money that it invested in that separate property house. Spousal maintenance is governed by 25319, and spousal maintenance has changed completely in the last several years because the legislature changed the law. So it is now much easier to get spousal maintenance than it used to be. You can count on spousal maintenance much more often than we could count on it before the legislature changed the law. So the law now has a calculator, and it now has presumptive guidelines like child support. So the same way child support is a calculator, everybody knows it's a calculator, there's not a lot of negotiation. That is really the direction that spousal maintenance has gone in, which is a huge change for Arizona family law. You've got custody, which is two things: legal decision-making and parenting time. Now, most people use the term custody. Arizona law uses legal decision-making and parenting time. Parents can have joint legal decision-making, which governs major decisions for your child: medical, educational, religious, and personal care. Those four categories count for legal decision-making, okay? Like whether or not you can get a driver's license. If you have joint legal decision-making, both parties have to agree before a child gets a driver's license or a passport. But if you have sole legal decision-making, the parent with sole legal decision-making can decide whether or not the child gets a passport or a driver's license. Whether to switch schools, that's another legal decision-making issue. Whether or not to take medication, whether or not to get braces, that's a legal decision-making issue, not a parenting time issue. Now, anything that is not a major issue in those categories that I just stated, if it is not a major legal issue, then it is a parenting time issue, and whoever has the child during their parenting time gets to make their choices. And then the other major issue we have is child support. So if you don't have children, your primary issues that you're dealing with are property issues or spousal maintenance issues. And then if you have children, we have to tack on legal decision-making, parenting time, and child custody. The other issue that sometimes gets thrown in there by lawyers is attorney's fees. Who pays whose attorney's fees? But I really don't think that that's like a core issue of divorce. And these 5 things are your core issues of divorce. Now, within each of these, we can have many sub-issues and little issues, right? What's community property? What's separate property? What's the value of the business? Lots of complexity can happen within each of these 5 simplified topics. To start your case, you begin with a petition, and you can draft a petition however you'd like. All right, you can find a form at azcourts.gov that you can fill out, but you can also turn that into a Word document as long as you cover all of the issues that you need to cover to add whatever information you'd like to add. So when lawyers file for divorce, we don't use the court forms. We do use our own version of the forms, and that's because it's more customizable. But you can do that too. You can use the court form or essentially make your own. And along with the petition, there are accompanying documents. Those are the summons, the sensitive data sheet, the preliminary injunction, and service forms. So I said the date of service is a particularly important date in Arizona divorce. Okay, that is the date that the community is terminated. So from the moment someone is served the petition, that is when the dollars that you're making at work are no longer community dollars. They are your own separate property. That's why it's a very important date. Any debt that is accrued after that date of service is not joint debt. And usually the date of service is also the valuation date for much of the property, although that's not always the case. The other thing that happens when someone is served with a petition is a preliminary injunction goes into place. At that point in time, if you have children, you cannot leave the state without an agreement between both parents. You also can't make any major changes to insurance beneficiaries. I suggest before you file for divorce, taking a look at your insurance beneficiaries, your retirement beneficiaries, and maybe even your will or trust to make sure it says what you want it to say, because you can't do it because of this preliminary injunction after someone files for divorce. The other thing I want to talk about is process service, okay? Service of process can be done either with a process server, by certified mail, or by an acceptance of service. And most of the time, it's one of these three, and usually the primary two are either an acceptance of service, where someone, the respondent, receives the documents and then signs in front of a notary saying, I have officially accepted these documents. You're not saying you agree with the documents. You're not saying everything in the petition is true. You're not saying I want what the other person wants. All you're saying is I have officially received the documents. Or usually a process server is hired, but you can't just give the paperwork to your spouse and say, now you've been served here in Arizona. Now in Oregon, where I used to practice, anybody could serve documents except for a party. So you could have a friend serve your ex for you, but that was not the case here in Arizona. Look at that. I just went too fast. The other thing is that a proof of service must be filed, whether or not that is a statement from the process server saying I served so-and-so on X date, or if the service of process, the affidavit of service that was signed, the acceptance of service signed in front of a notary, that can also be filed to put that official date in the court's file to let them know this is when the community ended. Next up, we've got, I'm actually going to go here first. We could talk about either of these interchangeably, temporary orders or disclosure and discovery. So let's talk about temporary orders first. Let's say you file for divorce and there are all these issues right now that have to be addressed because it can take a long time to get divorced, even after you file the petition. Like, who's going to pay the bills? Who's going to be responsible for paying the mortgage? Who's going to pay the car payment? Where are the kids going to go? When is my parenting time? When is your parenting time? I need temporary spousal maintenance and child support. All of those would be reasons to ask for a temporary order. And you file a motion under Arizona Rules of Family Law Procedure 47 for any of those things I just talked about. You can also ask for a temporary order that divides liquid assets on a temporary basis. So let's say you guys have a money market account with 80 grand in it. You can ask that the court require that to be divided, or savings account that's sitting there. You can ask that that be divided, or you can ask for any of the other things I was talking about: temporary custody, temporary support, temporary decision-making, temporary spousal maintenance, temporary payment of bills, even exclusive use of the marital residence. You can also ask on a temporary basis for exclusive use of the residence. You can file this anytime, either along with your petition for divorce or anytime during your divorce if you need a temporary order. And you're going to get this trial faster than you're going to get a final evidentiary hearing. And if you file a motion for temporary orders, the other side gets to respond, and then the court will schedule either an RMC or a temporary orders hearing, or an RMC and a temporary orders hearing together. Now, different judges do it different ways, different counties do it different ways. This is out of Coconino County, so I'm not sure if in Coconino County they typically will put together the resolution management conference and the temporary orders hearing, but here in Maricopa County, it does happen. I want to go back now and talk about disclosure and discovery. These are governed by Arizona Rules of Family Law Procedure, Rules 49 through 51. And if you're going through a divorce, it's really important that you look at these specific rules, okay? So I haven't said that about any other specific rules. These are rules that you should absolutely go look at. And I've got handouts also on my website and through the navigator that will tell you what is Rule 49. Rule 49 is a mandatory affirmative disclosures. So you have duties by the court and by the law to affirmatively give the other side certain information. And those duties are outlined in Rule 49. 51 is all about experts. And 50, I believe, deals with subpoenas. Disclosure and discovery is what must I give to the other side, and how can I find the information I need if they're not giving it to me proactively? Okay. And the way that I like to think about disclosures and discovery is you've got your big issues, right? Your parenting time, legal decision making, child support, spousal maintenance, property division. And under each of those, there are elements. So child support, for instance, the elements of child support, the way you figure out child support is mom's income, dad's income, or spouse one income, spouse two income, parenting time, cost of insurance, cost of childcare. You need evidence to support each and every one of those 5 things I just mentioned. Okay. So if you need to prove your income and dad's income, and you guys are both W-2 employees, all you need is a paycheck from you, paycheck from dad, or a tax return showing how much money you made. But let's say you're not W-2 employees, somebody is self-employed, or somebody is a business owner. Now you need a lot different information in order to figure out income to put it in that child support calculator. And there are things that you need to do. So in addition to Rule 49, you are required to file an affidavit of financial information. And that is, I would say, a relatively complex form that you have to fill out, and it's required to be filed. Disclosures, when you give them to the other side, those don't get filed. And one thing that's really confusing in divorce is what has to be filed and what doesn't. The rules will tell you, but also if you join something like the Modern Divorce Support Group or the Navigator, people will walk you through it. But it's important for you to know some things get filed, some things don't get filed. Let's say you need information and they're not giving it to you. Like, let's say that your spouse is a business owner and you need information from that business to determine their income for child support and spousal maintenance purposes. And they're not giving you the information. They are required to under Rule 49, but you need to use the discovery tools, which are request for production of documents, interrogatories, subpoenas, request for admissions, and depositions. Those are really your 5 discovery methods. And that you can use those to gather information. So you can subpoena the business, or you can do a request for production of documents to the spouse. Then there are deadlines. And then if they don't give it to you, you can file a motion to compel and ask the court to compel them to give you the information that you need in order to make your case. Not every divorce requires discovery. There is a form, uniform interrogatories, that are very useful. And I would recommend if you're in a contested case that you take a look at the uniform family law interrogatories, and you might as well send them. There are 40 questions and they're really good questions, and they will help you get the information you need. When you send discovery, there is a deadline by which time they must respond. Okay, it's 40 days for interrogatories and 40 days for admissions, but I could be wrong. And the rules 49 through 51 will tell you exactly what the timeframes are. They have to give you a response, which is really nice. The affirmative duty to do disclosures under Rule 49 doesn't always get you there, doesn't have the same teeth that discovery has. Talked about temporary orders. Let's talk about settlement versus trial. There's a lot of ways that people can reach settlement. Mediation is one of the most effective and often used tools to help people get themselves a settlement on the issues they don't agree on. And there are different counties, again, do this in different ways. In Pinell County, the judges assigned to the cases have settlement conferences, open negotiations in their courtroom to help people get settlements. Some judges will call lawyers back into chambers, which is really just the office in the back, to say, hey, here's what I'm thinking about this. Here's how I think you should maybe move forward. And that is a way that you can get some insight to help people settle. There's parenting conferences that people can be sent to where they may be able to reach agreements. There's also conciliation services through the county that is like a mediation that helps you figure out your agreements. And then there's private mediation. A private mediation is very, very effective. The vast majority of the time, when people go to private mediation, they end up settling the case. I would say 80% of the time. And I think it's a better outcome usually for families if something can be mediated. Now, it doesn't always work that way. I think 20% or so of divorces probably go to a final evidentiary hearing, but I'm just estimating. And that's when a judge decides. So if you go to mediation or you get an agreement and it's not a total agreement, so you can't turn it into a consent decree, but it's a part of your divorce that you agree on, like you agree on the decision-making and the parenting time, but you haven't decided the other things, you can put together what's called a Rule 69 agreement. Rule 69 covers binding agreements, and as long as that agreement is signed by both people, it will be enforceable. It has to go to a judge to be signed off on. The judge has to approve that Rule 69 agreement, but the vast majority of the time they do it. And so if you can get a partial settlement, take the issue off the table, okay? Take whatever agreements you can get, lock them down in Rule 69 agreements, because then you have fewer and fewer things that you're arguing about. Okay, and it's very easy and it's very tempting for people to become convoluted in their negotiations, and as opposed to just take it issue by issue. But when you go to mediation, this is why it's so successful. They isolate the issues. They make you come to agreements and help you to come to agreements on the things that you really agree on, so that then you can set aside your disagreements until we get there. It's a very effective way of doing things. And then if you reach an agreement on all things, then you can do a consent decree signed by both parties, submitted to the court for the judge's signature, so you can get divorced that way. Representing yourself in court. We have an entire course on this, trial skills and how to behave in court, because it's so confusing. There's so many rules. It's a culture. And I would recommend that you try to learn this culture if you're representing yourself in family court. How do the judges think? How do the lawyers think? What does this family court culture think is normal? Because it might be very, very different than what you think is normal. And the reason it's relevant is because many, many people go into family court and experience absolute culture shock at the things that the judges are saying, at the things that the lawyers are saying, at the things that are important to you that aren't important to them. And one of the best examples I can give you is what happened during your marriage. So what happened during your marriage is not important to judges and lawyers. I'm saying that with a broad brush. It's not entirely true. If there was domestic violence, if there was alcoholism, if there was major incidents, then the court cares. But let's say what many times happens is mom and dad go into court and mom says he has never been a present parent. He has never spent time alone with the kids. I have done absolutely everything. He should not have custody. And the culture of the family court does not care. Divorce is a reset. It's a do-over. It's a fresh start for everybody. And the initial starting point for most judges and most family law attorneys is if two parents are good parents, good enough parents. You could have an A parent and a C parent, but if they're good enough, then the court's position is going to be start from a place of 50-50. And it's important for you to know that because it may be very important for you to not have 50-50. It may be very important for you to have your kids during the school week if you can. And if that's the case, you need to know what the judges are going to do so that you can enter into the appropriate settlement, because you can't expect a judge to do that unless you have very specific facts that tell the court that this parent shouldn't have their children half the time. Okay, so it's really important that you learn, how do judges think about these cases and these issues? How do they usually treat them? Now, more practical tips. You want to dress rather formally. A courtroom may be the most formal environment you've ever been in. It's probably more formal than your church. You are expected to address the judge as Your Honor. You will probably be addressed by Ms. or Mr. instead of by your first name, but that could go either way. You want to be respectful, you want to be organized, you want to be polite, and you want to understand the formality of the room. Now, our culture doesn't love formality. Our culture really doesn't love hierarchy, but in the courtroom, that's the way it goes. And so you need to know that so that you can go in so that you can be successful, okay? You're going to want to be organized and do a trial outline. Okay, this is another thing that we go over in our trial skills course. It's free. You can access it at navigator.mymodernlaw.com. Trial skills course, you'll need a trial binder, a trial organizer. You will want to have your exhibits organized, your strategy. You'll want to know what that is going into the courtroom on each of those issues. Most of the time, when you are presenting evidence for the court, you want to present it in issue by issue. Okay, so it's, hey judge, right now we're talking about child support. This is mom's income, this is dad's income, here's our parenting plan that we've already agreed to. Or mom and dad disagree about parenting time, but under mom's plan, this is what the child support would be. Under dad's plan, this is what the child support would be, the parenting time, because that's a factor. Here's who pays for insurance. Here is the cost of that insurance. Here is childcare. Here's the cost of that childcare, right? So you would need all of those exhibits and all of those positions, and then you would need to admit them before you go on to the next issue. And you would want to build on that issue maybe and go to spousal maintenance next. All right, judge, now we're talking about spousal maintenance. As you know, we've discussed income. Mom's income is this, dad's income is this. The other factor for spousal maintenance in the spousal maintenance calculator is the principal paid on the primary residence mortgage. So that is another piece of information and an exhibit that you would want to admit to show the evidence to back up your position. And then you would want to ask for what you want to ask for. Judge, here's mom's income, here's dad's income, here's how long we've been married, here's the principal mortgage, here's the family size. Those are all the things that go in the spousal maintenance calculator. The range presented in the calculator, judge, is from this to this. I am asking for this amount because, and then you would want to use those spousal maintenance factors in order to tell the judge why you were requesting a specific amount within the given range of spousal maintenance. Facts and timelines are great. There are things called demonstrative exhibits. You are allowed to make your own exhibit called a demonstrative exhibit, which is like a summary, as long as you have the underlying exhibits that back up every piece of data in your summary exhibit. So let's say you put together a timeline, okay? Timelines are lovely, but you would want evidence to support your timeline. You need to authenticate it. You need to ask that your evidence, you need to offer your evidence for admission. It's formal, it's technical, and these are rules that you're going to want to know. So for the exhibits, we use case lines in Maricopa County. I'm not sure if in Coconino County you use case lines, but the way that exhibits work is they are uploaded in advance to a system. That's how we do it here. And then the judge has access to that in advance, but the judge is not going to look at your exhibits in advance of your trial. The judge may or may not read your pretrial statement in advance of your trial. The reason that you submit your exhibits in advance is because those go to the clerk of the court. And in the trial, if you get your exhibits admitted into evidence, then they become part of your court record. The court record is important for appeals. If anybody has to appeal, the appeal will be based solely and completely on the record, including what exhibits are admitted into evidence. So you're going to want to have all of your exhibits and the opposing party's exhibits with you when you go to court to make sure that you can talk about the exhibits, cross-examine those, object if you don't want them to be admitted into evidence. Here are resources that I want you to know about because I've given you a ton of information and it can be very overwhelming. So we've got the Modern Divorce Navigator, free, check it out. You can get courses, you can get handouts. It's fabulous. Modern Divorce Support Group on Facebook, 20,000 people, also free. You'll get a ton of information and you'll get to learn the culture. Legal aid or community legal services is a resource. If you qualify, check that out. You've got resources like these, AZ Law Help. You've got Law Library and then self-help centers. There are also legal document preparers available here in Arizona and legal paraprofessionals. So there are, I think, probably more resources and more accessibility here in Arizona than in most states. Get support, get mental health support, get access to resources. By resources, I mean friends, I mean family, I mean other people who have gone through a divorce or are going through a divorce. Because you want to, none of us are at our best when we're going through a divorce. And it's difficult to make major, huge, life-changing decisions when you're experiencing a diminished capacity. And I'll tell you, I went through a divorce, and I went through a divorce in 2017. So this was 12 years after becoming a family law attorney, right? So I knew the culture and I knew the law inside and out, and I still experienced diminished capacity during my divorce. You can count on it, which is why you need to give yourself grace, get yourself support, get yourself resources, and try to prioritize the long-term outcomes of your children. Try to think about like long-term, what do I want for my family? Because you're reorganizing, you're still going to be a family. Your ex is still going to be part of your family. It's just more like an extended family now. And I want you to really prioritize your children and caring for your own well-being. You can do this. People do successfully represent themselves in family court every single day. But in order to do it, you have to be prepared. You have to be organized. You have to get yourself, you have to spend the time putting this together and doing it the right way. If you're not going to have a lawyer, you have to commit to significant resources of time to learn this, to do this well. Okay. You cannot just wing it. But that's why these resources exist, to teach you how to do well yourself in court. Stay organized, stay informed. The dates, the deadlines, they're real. You can't blow off deadlines. It won't be okay in family court. I know in real life, deadlines are mostly fluffy. These are not fluffy deadlines. They are real. Breaking the deadlines has significant consequences. And seek legal advice and support when you need it. All right, that is it for me. I would love to now open it up to Q&A. I see we've got 10 or so questions in the chat. And go ahead and put any other questions that you have in the chat. All right, here's the first question. If there are no minor children and he can have everything still on the property, I only took personal things, not valuable, and there's no spousal maintenance, can I file a summary consent decree without seeing or speaking to him? That is an excellent, excellent question. But the answer is no, you can't. You can only file a summary consent decree if both people sign off in advance. But what you're proposing is what I like to call a walkaway divorce, where like you take your stuff, I take my stuff, like there should be nothing to fight about. And you may be able to get a default, and you certainly should be able to get a settlement, but that is not a time when you can do the summary consent decree process that we talked about. Next question. If you have a trial set within 2 months and one party is not providing disclosures, should the other party file a motion for default? That's a fantastic question, but no, you only file for default if someone doesn't file a response. You need to you need to file a request for discovery, like a production of documents or interrogatories, like we talked about, to get that information. And also, I would encourage you to really think about what specific information do you need and what are the various ways that you might get that information? Because if you have a difficult opposing party that is not giving you the information you need, then your best bet may not be to try to get it from them. You may be better off subpoenaing it from a bank or from a different third party. Does the adoption subsidy count as income? And can we count childcare? And will that come up to the divorce because we have childcare needs? Okay, so on the adoption subsidy, I want to see if I can look this up for you real quick. What I would do right now is look at the Arizona Child Support Guidelines. And the Arizona Child Support Guidelines, because income is different depending on what you're counting it for. So I think what we're talking about is child support. And there are certain things that count as income for child support, but they don't count as income for spousal maintenance. So I'm just gonna get into the child support guidelines and look at this for you. Now, I want to talk about, while I'm looking this up, can we count childcare that we have come up due to the divorce? Okay, so your childcare needs are changing now because of your divorce, and you're wondering if that's going, if that is going to, if you can include that in the child support calculator. You can, but the thing to know is that whether or not to include childcare is a discretionary factor. Childcare is not always included in the child support calculator. Sometimes you have a different order that says childcare will be covered by the parties in a percentage split, or mom covers childcare during her time, dad covers during his time. I think I've had this issue in the past where I've had clients that had adoption subsidies and it did count as income in the child support guidelines, or it counted as part of the obligation. So the obligation, might have been dad to pay mom $1,000, but mom got the $1,000 from the adoption subsidy, so dad didn't have to pay child support. That sounds like, if I'm remembering correctly, that's what happened. But you would want to look specifically at the Arizona Child Support Guidelines. It has so much information in it. All right, since there isn't enough space to completely fill out the pretrial statement, could a Word document be used? Yes. In my opinion, your pretrial statement is the most important document in your whole case if you're going to court. And it's the thing that if you only see a lawyer to help you with one thing, if I had to choose that, it would be the pretrial statement, because it is so important. Everything goes in it. All of your arguments, all your exhibits, your objections to their exhibits, any legal research that you've done, any case law that you've looked up. It's just a critical document, and you can also use it as your outline while you are representing yourself through your case. So yes, I would recommend that you make it a Word document and don't use the forms. And then could the pretrial statement be uploaded early? Yes, but I don't know that I would do that, because what if something happens and you need to change it? Family law is so different than other types of law because things are changing all the time. The case is never stagnant. Things happen that change your strategy or change your position, and for good reason. So I probably would not file it early. All right, there's another question here. Is the 90-day requirement counted as consecutive days? Are you talking about for residency? I think that the question has to do with residency. No, you're allowed to take vacations. You're allowed to go out of state. You just have to live in Arizona for 90 days. Next question. What happens after a motion to compel is issued? He was given more time to produce financial documents and the HIPAA information and still hasn't produced anything. What's the next? Is it to file a subpoena? Okay, so this person is trying to get a HIPAA release signed by the other party and other financial information. They already filed a motion to compel. They already saw a judge about that. The judge did issue an order to compel, and they still haven't done it, the other side. I would probably file at that point a notice of noncompliance or a petition for contempt. That's probably what I would do. And then in terms of how to get the information, most of the time you cannot get healthcare information without a signed HIPAA release. I don't know that anybody is going to respond to your subpoena without them filing that HIPAA release. So depending on what the other documents are, maybe we could figure out a way to do that. I'm just starting the process. Is it the correct order to do the petition and then file the consent decree and then go to private mediation? No. You only file the consent decree after you have an agreement on all things. So yes, file a petition, then go to mediation if you can't come up with an agreement in a different way. And then once you get your agreement and it's written down and it's signed by both of you, that's when you submit your consent decree. All right, thank you all so much for your time today. I hope that this has been useful and helpful, and good luck everybody with your cases.